We're going to decode this red book. We've got the general conditions, the contract data, the special provisions, the whole stack. We want to understand the rules of engagement for these massive international projects. Because, let's be honest, I felt intimidated just opening the PDF. It looks like a phone book written by lawyers for other lawyers.
It can be intimidating, I get it.
Yeah.
But don't let the density fool you. At its heart, this document is a mechanism for fairness.
Fairness.
Yes, it's an operating system designed to prevent chaos on a job site. It defines who pays, who bills, who takes the risk, and what happens when, not if, but when things go wrong.
And in construction, things always go wrong, don't they?
Invariably. You are dealing with physics, geology, weather, and human beings. It is a recipe for unpredictability.
So before we dive into the specific clauses, and we're going to cover everything from finding archaeological ruins to what happens if the employer just gets bored and cancels the project.
And yes, that is a thing.
Let's set the stage. Why the red book? I know FIDIC has a whole rainbow of contracts. There's a yellow book, a silver book. Why are we focusing on red?
Great question. So FEI stands for the International Federation of Consulting Engineers. They produce this whole suite of contracts, and they color code them based on how the project is structured. The Red Book is the global standard for construction where the design is done by the employer.
So the employer hires an architect or an engineer first. They do all the drawings, and then they hand them over.
Exactly. You, the employer, get your team to draw up the blueprints, calculate the loads, and specify all the materials. Then you hire a contractor to build exactly what is on those drawings.
Okay, so in this model, understanding these clauses is all about how risk is shared between the employer, the one with the money, and the contractor, the one with the boots on the ground.
Precisely. And the 2017 edition is really interesting because they have tried to clarify that balance and, crucially, to stop disputes before they burn the whole project down.
Let's jump right into part one then, the ground rules. This is clause one, general provisions. Now, usually I might skip the definitions section in a contract because it feels like housekeeping.
A huge mistake.
But reading through this, I realized that the definitions are actually where the landmines are buried.
You absolutely cannot skim Clause 1. This is where the language of the law is defined. If you don't know who the players are, you don't know the game you're playing.
So let's meet the players. We have three main characters in this story. First, the employer.
Right. The entity paying for the work. But look closely at the definition in the text. It includes their legal successors.
I circled that. Why is that specific phrase so important?
Because these projects take years, sometimes decades. Companies get bought, sold, or merged. If I sign a contract to build a power plant for Company A, and 2 years later, Company A gets acquired by a massive global conglomerate, I need to know that the contract still holds.
I see.
The legal successor clause ensures that the new owner steps into the shoes of the old one. They can't just walk away and say, well, we didn't sign that.
That makes sense. It provides continuity.
Yeah.
Okay, then we have the contractor.
Defined in subclause 1.1.1. This is the person or company named in the letter of tender accepted by the employer. They are the ones executing the work. They are the ones taking on the physical risk.
And the third wheel, the engineer. This one seems unique to the FIDA model.
It is central to the Red Book. The engineer is appointed by the employer to administer the contract. This is a fascinating role because they wear two hats.
How so?
On one hand, they are hired and paid by the employer, but on the other hand, the contract requires them to make fair determinations.
That sounds like a conflict of interest waiting to happen.
I'm paying your salary, but I need you to decide against me if I'm wrong. It is the source of endless arguments in the industry. But under Clause 3 of the 2017 edition, the engineer's duty to act neutrally when making determinations is much more explicitly defined.
Okay.
They aren't just a mailman for the employer. They are supposed to be the referee on the field.
Let's unpack the power of words here. Subclause 1.2, regarding interpretation. It feels like high school grammar class, but with millions of dollars at stake.
It really is.
There is a massive difference between the words may and shall.
It is the most important distinction in the entire document. If you take nothing else away from this deep dive, remember this. Under subclause 1.2, shall means an obligation.
An order.
A duty. If the contract says the contractor shall submit a report, there is no wiggle room. You must do it. If you fail to do it, you are in breach of contract.
And may.
May implies a choice. The party has the option to act or not act. The engineer may inspect the works. They can choose to do so or not. It's permissive. If you confuse shall and may when you are writing a letter or making a claim, you can accidentally waive your rights or accept a liability you never intended.
I also noticed the definition of written. We live in a digital world now. In 2017, does written still mean a quill on parchment? Or does a text message count?
Thankfully, they modernized this. Written, or in writing, means handwritten, typewritten, printed, or, and this is key, electronically made.
Okay, but there's a catch.
There is a catch. It must result in a permanent record.
So if I send a message on a secure app that auto-deletes after 24 hours.
Not written, doesn't count.
What about a quick Zoom call where the engineer tells me to change the design, but nobody records it?
That is definitely not written under the contract. And this is a trap contractors fall into all the time.
I can imagine.
The engineer says something on site, the contractor does it, and later there is a dispute. If there is no permanent electronic record, like an archived email or a formal digital instruction, it didn't happen.
That is a huge takeaway. If it isn't written, it didn't happen. Now let's talk about subclause 1.6, the contract agreement. It says the parties shall sign within 35 days after the contractor receives the letter of acceptance. Who pays for the stamp duties?
The employer. The text is explicit there. The costs of stamp duties and similar charges imposed by law fall on the employer. It's a small detail, but it shows you how specific the Red Book gets about who pays for what.
And then we hit subclause 1.15, limitation of liability. This seems like the safety net for the contractor.
It is. Generally, the total liability of the contractor to the employer is capped. It's usually a sum stated in the contract data. If it's not stated there, it defaults to the accepted contract amount.
So if I'm building a bridge for you for $10 million and I make a mistake that causes massive delays, you generally can't sue me for $50 million.
Generally, that's the key word.
Okay, so what's the exception?
The exception is a big one. This cap does not apply in cases of fraud, gross negligence, deliberate default, or reckless misconduct.
So if I'm just incompetent, my liability is capped. But if I'm reckless?
If you decided to use cheap, substandard steel to save money and pocket the difference, that is fraud or reckless misconduct.
And then the cap is gone.
The safety net disappears. You are liable for every penny of damage, even if it exceeds the contract price. You can't contract your way out of fraud.
That makes perfect sense.
Yeah.
Okay, moving to part 2, the setup. This defines the duties of the two heavyweights, the employer and the contractor.
Let's start with the employer in Clause 2. What is their biggest responsibility aside from, paying the bills?
Right, of access. Subclause 2.1, it sounds incredibly simple. The employer must give the contractor right of access to the site.
You can't build a building if the gates are locked.
Exactly. But this happens right all the time. Maybe the employer hasn't finished purchasing the land.
Or there are protesters.
Maybe there are squatters living on the site. Maybe there's a political protest blocking the road.
And if the contractor is sitting there with a fleet of bulldozers and 500 workers and they can't get in, it triggers claims for delay. The meter starts running.
Immediately.
If the employer doesn't provide access by the date in the contract data, the employer is going to pay for that downtime. And idle construction equipment is incredibly expensive.
I bet. What about permits? Who is responsible for getting the legal permission to build?
Subclause 1.13 covers compliance with laws. It's a split responsibility, which is interesting.
Right.
Generally, the employer obtains the planning permissions, the right to have a building on that land. But the contractor has to obtain the permits required to execute the works. Things like road closure permits, crane operation licenses, or labor visas.
Now let's flip the coin to Clause 4, the contractor's burden. This section feels heavy.
It is.
Subclause 4.1 says the contractor is responsible for the adequacy, stability, and safety of all site operations. That covers a lot of ground.
It covers everything. If a scaffold falls, it's the contractor. If a trench collapses, it's the contractor. But the real sleeper clause here, the one that keeps project managers awake at night, is subclause 4.1. Site data.
I marked this one. It says the contractor is deemed to have satisfied themselves regarding the form and nature of the site.
Deemed to have satisfied themselves. That is powerful legal speak. It means you are legally considered to have checked everything, whether you actually did or not.
So you're supposed to have checked the ground conditions, the weather.
Before submitting a tender, the contractor is supposed to check the hydrological conditions, climatic conditions, the subsurface conditions, basically everything.
So let's play this out. I'm a contractor.
Huh.
I bid on a tunnel project. I start digging, and I hit a massive wall of hard rock that wasn't shown on the initial drawings.
Right.
It's going to cost me 10 times as much to drill through it. Can I go to the employer and ask for more money?
Under the Red Book, that is a very, very difficult argument to make.
Why?
The employer will point to Clause 4.10 and say, you were deemed to have satisfied yourself about the geology. You should have drilled more test boreholes before you bid.
But bidding periods are short. Sometimes you only have a month to put a price together. You can't drill holes everywhere.
And that is the risk. This clause represents a massive transfer of risk from the employer to the contractor.
So you have to price that risk in.
You have to. Unless the condition was unforeseeable, and FIDIC has a very strict definition of what unforeseeable means, the cost of that rock belongs to you. You can't come back later and say, I didn't know the ground was soft, or I didn't know the water table was this high.
That puts a huge premium on doing your homework.
It effectively punishes optimism. If you assume the best-case scenario for the soil, you are gambling.
What about getting to the site? Subclause 4.15 talks about access routes.
This is another risk transfer. The contractor is responsible for maintaining their access routes. And here is a specific detail from the text that I find fascinating.
Go on.
The contractor must prevent roads or bridges from being damaged by their traffic.
So if I drive a 50-ton dump truck over Sleepy Village Bridge to get to the site, and the bridge collapses,
You just bought a bridge. Or at least you are paying to fix it. The contract says you must use appropriate vehicles and routes. You can't just destroy the local infrastructure in the name of progress.
the environment also gets a mention in Clause 4.1 key.
Yes, protection of the environment. In the 2017 edition, this is much stricter. It is an explicit requirement to limit emissions, surface discharges, and effluent.
So no more just pumping wastewater into a river.
You can't just pump your muddy construction water into the local trout stream. If you do, you are in breach of contract, not just environmental law.
And subclause 4.19 covers temporary utilities. I assume the contractor can't just plug an extension cord into the employer's office.
Correct. The contractor is responsible for their own power, water, and services, unless the contract states otherwise. They usually have to bring in big diesel generators.
Okay.
If they do use the employer's utilities, the text says the employer is entitled to payment for it.
Moving on to Part 3, the human element. Construction isn't just concrete, it's people. Clause 6 deals with staff and labor.
This section is quite fascinating because it deals with the reality of managing a workforce, often in a foreign country.
Right.
Clause 6.3 is straightforward. The contractor handles recruitment, payment, and feeding of their staff.
But Clause 6.5, working hours, caught my eye.
Hmm.
It says no work on locally recognized days of rest.
Right. You have to respect the local culture. If you are building in the Middle East, Friday might be the day of rest. In Europe or the Americas, it's usually Sunday. You don't work on those days unless the engineer consents.
Oh, reason or, isn't there?
Or, and this is the dramatic part, if it's an emergency to save life or property.
I see.
If a retaining wall is failing and threaten a village, you work on Sunday. The contract recognizes that safety trumps the calendar.
There's also Clause 6.11, disorderly conduct.
I call this the bouncer clause.
The bouncer clause.
Yeah. The contractor must prevent disorderly conduct among their staff. But more importantly, it gives the engineer power. If a worker is acting dangerously, or they are drunk, or they are starting fights, the engineer can effectively demand their removal from the site.
And the contractor has to listen.
Yes. They have to remove that person and replace them, usually at their own cost. It ensures that the engineer has some control over safety and discipline, even though they aren't the direct employer of the workers.
Clause 6.12 mentions key personnel. This feels like a protection against a bait and switch.
That is exactly what it is. When contractors bid for big jobs, they often put their A-team in the proposal.
Sure, you want to show off your best people.
They say, look, we have Jane Smith, the world's best bridge engineer, and she will run this project. The employer hires them based on Jane.
And then, once the contract is signed, Jane disappears to another job.
Exactly. Clause 6.12 prevents that. It says the key personnel named in the tender must be available. You can't swap Jane out for a junior engineer without a very good reason and the engineer's consent.
So you have to deliver the team you promised.
You do.
Okay, let's get to the actual building part, Part 4. The work itself. Clause 7 is quality control. How do we ensure the concrete is actually concrete?
This is where the rubber meets the road. Subclause 7.1 dictates the manner of execution. Workmanship must be of the quality specified.
But how do we know it is?
That's subclause 7.3 and 7.4, inspections and testing. The employer's personnel are entitled to examine, inspect, measure, and test materials. And this applies not just on the site, but often at the place of manufacture.
So the employer can send someone to the steel mill in another country to check the beams before they even ship.
Yes. And if they fail the test, subclause 7.5, defects and rejection. If the work is defective, the engineer can reject it.
Then the contractor has to fix it.
They have to fix it or replace it at their own cost.
There's an interesting point in subclause 7.7 about ownership. It says, plant and materials become the property of the employer when paid for. Why is that so specific?
This surprises people, but it's a crucial protection against bankruptcy. Imagine the employer pays $5 million for a set of custom turbines.
Okay.
They are sitting in a warehouse in Germany, waiting to be shipped. Suddenly, the contractor goes bankrupt.
If the contractor owns them, the creditor sees the turbines.
Exactly. But this clause says, no, the employer paid for them. They belong to the employer. It allows the employer to go and claim their property even if it hasn't arrived on site yet.
That's clever.
It separates the materials from the contractor's financial risks.
That leads us to clause 8. Time is money. We have a commencement date and a time for completion.
The clock is always ticking. Clause 8.2 sets the deadline, but construction is rarely perfectly on time. So Clause 8.6 and 8.7 deal with what happens when things slow down.
Delays.
Right. If the authorities cause a delay, say, the government is slow issuing a permit, the contractor might get an extension of time, or EOT.
So the deadline moves back.
The deadline moves back, and they don't get penalized for it.
But what if the contractor's just slow? Maybe they didn't hire enough trucks.
That is a different story. That is subclause 8.7. The engineer can instruct them to expedite the work.
Which means hurry up.
It means hurry up, add more shifts, work at night, bring in more equipment, and crucially, the contractor bears the cost of that acceleration.
And if they don't speed up,
Subclause 8.8, delay damages. This is the stick.
the penalty.
It's a penalty, usually a percentage of the contract price for every day they are late.
Yeah.
It can get very expensive very quickly. It's designed to make it more profitable to finish on time than to be late.
What about stopping the work entirely? Suspension.
That is clause 8.9 through 8.2. The engineer can suspend the work. Maybe there's a safety issue, or maybe the employer just needs to pause for funding reasons.
But the contractor gets paid during this time.
Usually, yes. They get paid for the cost of protecting the works. And clause 8.11 says they get paid for plant and materials if they are marked as property of the employer. But here is the really interesting strategic element. Subclause 8.11, prolonged suspension.
How long is too long?
The contract says 84 days. If the suspension lasts more than 84 days, the contractor can ask for permission to proceed.
And if the engineer says, no, keep waiting.
Then the contractor can treat the suspended part as an omission, basically removing it from the contract.
And if the whole project is suspended for that long?
They can terminate the contract. It prevents the employer from keeping the contractor in limbo forever. It's a game of chicken. You can pause the game, but if you pause it too long, the other player quits.
Let's fast forward to the end of the job. Part 5. The finish line. Clause 9 covers tests on completion.
You can't just hand over the keys and walk away. You have to prove it works.
Right.
The contractor runs the tests, pressure testing pipes, load testing bridges, running the AC.
And if they fail?
Subclause 9.4, they have to repeat the tests.
And if they fail repeatedly? I mean, what if they just can't get it right?
The employer has options. They can order another repeat, they can reject the whole section, or, interestingly, they can issue a taking over certificate anyway, but reduce the contract price.
Oh, that's interesting.
It's basically saying, I'll take this defective building because I need to use it, but I'm paying you less for it because it doesn't meet the spec.
Speaking of taking over, that's Clause 10.
Subclause 10.1. The engineer issues a taking over certificate when the work is completed. This is a huge milestone. It shifts responsibility for the care of the works from the contractor to the employer.
The risk transfers back.
Exactly. The insurance requirements change. The risk transfers back to the owner.
I found subclause 10.3 hilarious.
Wow.
Interference with tests on completion.
Yes. I call this the stop hitting yourself clause.
Why is that?
Sometimes an employer doesn't want to take over the building yet. Maybe they don't have the final payment ready, or they aren't ready to occupy, so they might try to delay the tests.
It's like they locked the door to the electrical room or something?
Exactly, it happens. But Clause 10.3 says if the employer prevents the contractor from doing the tests for more than 14 days, the tests are deemed to have been passed. The contract assumes the building works because the employer wouldn't let them prove otherwise. You can't pluck the exit and then complain the contractor hasn't left.
So once the taking over certificate is issued, is the contractor free? Can they go home?
Not yet. Clause 11 is defects liability. In other industries, you'd call this the warranty period.
Okay.
It's usually a year, sometimes two, called the defects notification period, or DNP.
How does that work?
Under subclause 11.1, the contractor must finish any outstanding work and fix any defects that appear during this period. If the roof leaks 3 months after the employer moves in, the contractor has to come back and fix it.
At their own cost.
If the defect is due to poor workmanship or materials, yes, at their own cost.
And finally, when is it really truly over?
Subclause 11.9, the performance certificate. This is the true end. It's the only document that constitutes formal acceptance of the works. Once this is issued, the contractor's obligations are largely done.
Bonds get released.
The performance bond is released. The marriage is officially dissolved.
Okay, let's talk about the thing everyone cares about most. Money. Part 6. Financials and risk. Clause 14 is contract price and payment.
Subclause 14.1 defines the contract price. It's the agreed amount. But you have to remember, in construction, the price is rarely static. It's subject to adjustments, variations, claims, inflation.
And Clause 14.2 covers advance payment. This is like a startup loan, right, to get things going.
Essentially, for big projects, the contractor needs huge cash flow to mobilize, to buy equipment, set up the camp, ship materials. The employer gives an advance payment. Subclause 14.2 says this is an interest-free loan.
But nothing in life is free.
Correct. Clause 14.2.3 details how it's repaid. It is deducted from future payment certificates. Usually a percentage is shaved off every time the contractor sends a bill until the loan is paid back.
Subclause 14.15 caught my eye. Currencies of payment.
This is vital for international work. Imagine you are building a dam in Vietnam.
Right.
You pay your local laborers in Vietnamese dong, but you are buying turbines from Germany in euros, and you are buying steel from China in renminbi.
That is an accounting nightmare.
And a risk. If the exchange rate shifts wildly, you could lose your profit margin overnight. Clause 14.15 specifies exactly which currency is used for what. It locks in the risk profile so everyone knows where they stand.
Now let's look at the scary stuff. Clause 17, care of works and indemnities. This is about who gets sued when someone gets hurt.
Pretty much. Subclause 17.4 is indemnities by contractor. To put it simply, if the contractor breaks it or hurts someone, they pay for it.
So they indemnify the employer.
The contractor indemnifies the employer against bodily injury, sickness, disease, or death of any person, and damage to property caused by the contractor's operations.
So if a crane falls on a passerby.
The contractor deals with it. They hold the employer harmless, they pay the lawyers in the settlement.
But there is a flip side. Subclause 17.5. Indemnities by employer.
Yes. The employer indemnifies the contractor against things like the employer's negligence, or what they call the unavoidable result of the works.
What does unavoidable result mean?
Let's say the employer hires you to dig a canal. You dig it exactly where they told you to, but digging that canal drains the water table and dries up a nearby farmer's well.
Ah, okay.
You didn't do anything wrong, you just executed the design. The damage was unavoidable.
So the employer pays the farmer.
Correct. The employer takes the risk for the consequences of their design.
And subclause 17.6 mentions shared indemnities, acknowledging that sometimes it's a bit of both.
Exactly. Life is rarely black and white. Sometimes both parties share the blame, and the contract allows for that liability to be split.
We have arrived at the divorce section. Clause 15 and 16. Termination. This is when the relationship breaks down completely.
Clause 15 is termination by employer. It usually starts with subclause 15.1. Notice to correct.
A warning shot.
It is a warning shot. The engineer sends a formal notice saying, fix this specific failure or else.
And if they don't fix it?
Subclause 15.2 allows termination for contractor's default. This happens if the contractor abandons the work, goes bankrupt, or essentially demonstrates they have no intention of finishing. The employer kicks them off the site and calls in the bonds.
Which is a disaster.
It is a financial disaster for the contractor.
But then there is subclause 15.5. Termination for employer's convenience. This one seems wild to me.
It is a very powerful clause. The employer can terminate the contract at any time for any reason. They don't have to prove the contractor messed up.
So their funding could dry up, or...
Maybe the funding dried up, maybe the government changed and they don't want the dam anymore.
That seems unfair. Can they just fire the contractor and hire their cousin to finish the job cheaper?
No, that is the fear, right? But subclause 15.5 has a specific poison pill to prevent predatory behavior.
Wait, is it?
It says the employer cannot terminate for convenience in order to execute the work themselves or to arrange for the works to be executed by another contractor.
So you can cancel the project, but you can't just swap the contractor.
Exactly. You can kill the project, but you can't replace the player. If you use this clause, the project stops.
And Clause 16 lets the contractor fire the employer.
In a manner of speaking, if the employer doesn't pay, Clause 16.1 allows the contractor to suspend work. If they still don't pay, Clause 16.2 allows the contractor to terminate.
No pay, no play.
Exactly. No pay, no play.
And then they have to figure out the bill for what's been done.
Right. Valuation. The engineer has to figure out what the work done so far is actually worth, and the employer has to pay for it, plus usually some loss of profit for the contractor.
This brings us to Part 7. When they disagree, disputes. This seems to be where the 2017 Red Book really tries to innovate. Clause 20 deals with claims, but Clause 21 is about the DAB.
The Dispute Avoidance Adjudication Board, or DAOB. Note the word avoidance. That is the big innovation in 2017.
In previous versions, it was just a dispute adjudication board, right? The DAB.
Yes, the DAB. It used to be a panel you called when you were already fighting. It was reactionary. Now, under Clause 21.1, the DAB is appointed at the start of the project.
So they're like marriage counselors who move in on the wedding day.
That is the perfect analogy, and they stay there. Subclause 21.3 is titled Avoidance of Disputes. The parties can jointly ask the DAB for informal assistance.
How does that work?
Let's say we are arguing about that rock formation we found earlier.
Right.
I think it's unforeseeable. You think it's not. Instead of firing off aggressive legal letters, we can invite the DAB members for a coffee and say, hey, what do you guys think?
And they give advice, just informally.
They give a non-binding opinion. They might say, look, contractor, under Clause 4.10, you're probably going to lose this one. That allows the contractor to back down without losing face.
It stops the small fire from becoming an inferno.
That's the whole idea.
I was reading the appendix on the DAB duties. It creates a real obligation for them to be present, doesn't it?
Absolutely. The appendix rules say the DAB members must be knowledgeable about the contract and the physical progress of the works.
So they have to be technical people.
And Rule 3 covers site visits. They can't just sit in an office in Geneva or London. They have to visit the site regularly, usually every few months.
They need to see the mud and the concrete.
Exactly. If they don't know the project, they can't help avoid disputes. They have to be engaged.
And if the informal chat doesn't work?
Then you go to a formal referral. The DAA issues a binding decision. If one party is unhappy with that, they issue a notice of dissatisfaction.
And then, what's the final step?
Subclause 21.6, arbitration. Usually international arbitration, often under ICC rules. But the hope and the design of the 2017 Red Book is that most issues never get that far.
Because the DAB solves them first.
Right. Arbitration is the failure state.
Finally, let's touch on Part 8. Modern updates. The world has changed a lot since the previous edition in 1999. I saw mentions of BIM building information modeling.
Yes. 1999 was a paper world. 2017 is a digital world. The source text includes advisory notes to users regarding BIM.
And what do they advise?
The Red Book advises reviewing definitions in Clause 1.1 and intellectual property rights in Clause 17.3.
Why?
Because if the design is a shared 3D model in the cloud, who owns it? Who is liable if the file gets corrupted? The standard clauses need to be tweaked to handle digital data, not just paper drawings.
And that leads to special provisions. We've been talking about the general conditions, which are the standard boilerplate. But every project is unique.
Correct. The Red Book is a template. The contract data and the special provisions, which are called Particular Conditions Part B, allow you to customize it.
So you might need different insurance for a nuclear plant than for a road.
Precisely.
But there is a warning in the text, isn't there, about making changes?
A big one. The guidance warns that great care must be taken. These clauses are an ecosystem. They are interlocked. If you change one clause, you might unintentionally alter the balance of risk elsewhere.
Like the butterfly effect.
Exactly. If you delete the right of access clause because you think it's redundant, you might accidentally invalidate the contractor's ability to claim delays, which could make the whole contract unenforceable under local law. You can't just hack away at it with a machete.
So let's synthesize this. We have gone from defining the word contractor to handling massive international arbitration. We've covered the right of access, the site data risks, the disorderly conduct bouncers, and the termination for convenience nuclear option.
It is a comprehensive system. It covers the life cycle of a project from the first handshake to the final certificate.
What stands out to me is the shift towards prevention. The DAB seems like the MVP of this edition.
I agree. And the provocative thought I would leave the listener with is this. The contract tries to predict every possible future rain, strikes, bankruptcy, bad soil. It is a book of what ifs.
Right.
But the most important clause might be that avoidance of disputes mechanism.
Why is that?
Because it acknowledges that the best legal protection isn't a shark lawyer who can win a lawsuit in year 5. It is actually structured communication and informal assistance in week 5. It prioritizes talking over fighting.
It's the difference between winning a war and preventing one.
Exactly. Whether you are the employer or the contractor, knowing these 21 clauses isn't just about winning a lawsuit. It's about knowing the rules of the game so you can actually finish the project. Because at the end of the day, nobody wants a lawsuit settlement. They want a building.
They want a building. That is a great place to leave it. Thank you for guiding us through the dense but surprisingly dramatic world of the FIDI Red Book.
My pleasure. It was fun.
And to our listener, next time you walk past a construction site and see a crane swinging overhead, remember? There is an invisible web of shalls and mays and indemnities holding that whole operation together. Thanks for listening to The Deep Dive. We'll see you next time.